I'm former DUI prosecutor Neil Schaus, and I'm here with former DUI police officer Michael Scafidi. We both are now DUI defense lawyers here at Schaus Law Group. And Mike, today I want to talk about DUI laws for underage drivers. And just a few preliminary things. I mean, first of all, in the state of California, the drinking age is 21, right?
That's correct.
So you're not allowed to drink alcohol at all if you're under 21.
Correct.
And there is what we call a zero tolerance policy that you're not allowed to, if you're under 21, you can't drive a motor vehicle with any amount of alcohol in your system.
That's correct.
I mean, that's the law anyhow.
That is absolutely the law.
So let's say someone is underage, is 16, 18, 20. They get arrested for DUI. How is the law different for them because of their age?
In court, it's exactly the same standard as you're an adult. If your blood alcohol level is 0.08% or greater, a court could find you guilty, or a jury could find you guilty of violation of 23-152A, driving under influence of an alcoholic beverage, or 23-152B of the Vehicle Code. Now, where it truly differs is at the administrative per se level at DMV, where if your blood alcohol level is found to be 0.01% or greater, the DMV can suspend your license for 1 year.
So basically what you're saying is that there's two different cases. You got the criminal case, and that's the same standard as for adults. I mean, and that's really the sort of the misdemeanor criminal DUI conviction.
That's correct.
Is that even if they're under 21, the prosecutor still has to show that they're 0.08 or higher, or that they're under the influence.
That's correct.
But it's at the DMV that everything changes, and you got this 0.01 standard, which is different for minors.
Correct. A much, much lower threshold for the DMV to prove their case, which can result in that 1 year suspension.
How much alcohol does someone have to consume to get a 0.01 in your experience?
Quite candidly, a sip, half a sip of beer, an ounce of beer. In fact, we had a case recently we handled where the person gargled with Listerine, and they actually swallowed a little bit of Listerine, and they gave her a pass, a pulmonary alcohol screening test, the CHP did, and it measured 0.01%. And that case was a very difficult case to litigate with the DMV.
So at the DMV with this 0.01 standard, where basically you're a minor, you have consumed any amount of alcohol, then they can suspend your license for a year. If you do get the 1 year suspension, can you get a restricted license, or is there some way around it, or is it just a hard suspension?
That's a great question, Neil, and it's one that we're asked all the time as criminal defense lawyers at the Schaus Law Group. And the bottom line is this: you're not eligible for a restricted license, but under certain circumstances, you can get what's called a critical need license with DMV. For example, if you have to travel far distance for school and there's no rapid transit or buses that you can take there, you can request a hardship. And you do it by filling out an application with the Department of Motor Vehicles, and they'll make a determination as to whether or not you're eligible for a critical need license on a case-by-case basis.
And let me ask you this. I mean, you've successfully defended a lot of underage drivers who got DUIs. How do you go about it? I mean, what can you do for someone who's, let's say, 20 years old and they got arrested for DUI?
Well, that's a real it's a real conundrum sometimes because of this low threshold. But there are lots of defensive strategies we employ. For example, even though it's a zero tolerance case, the officer still has to have reasonable suspicion to believe that our client was driving a motor vehicle under the influence. They have to have reasonable suspicion to make a lawful arrest. And one of the subordinate issues of lawful arrest is whether or not they were lawfully detained. And so in those types of situations, we'll litigate that issue fully, oftentimes by subpoenaing the officers there to attack their account in their police report, to argue that the officer had no reason to contact our client, thus the DMV shouldn't even consider the evidentiary breath results. Also, we put into place arguments by experts that in fact there are other forms that can lead to a false positive reading. And one of the biggest things that we do to defend these cases is oftentimes the police officer makes a mistake in the collection of the evidence. For example, they only do one PAS device, which is a non-Title 17 of California Code of Regulations compliant device. They never get the second PAS sample, and there's case law to support that there has to be two PAS samples, and we often attack cases because of police error in the collection of evidence in zero tolerance cases.
So a lot of people think when the minor gets arrested and has sort of any amount of alcohol in their system, that's just the end of the story because of the zero tolerance law. But what you're saying is with a good DUI defense lawyer, it might be possible to avoid that 1-year suspension altogether.
No, that's correct. And just by the way, I just talked about, plus by subpoenaing records to see whether or not the PAS device that was used, or the evidentiary test device that was used, breath machine, was properly functioned, maintained, and calibrated. If it's not, we will argue to the DMV and even to the courts that their results should be excluded under California law.
And even if let's say the minor gets the 1-year suspension at the DMV, I mean, they still have the court case. And so as a DUI defense lawyer, I mean, you might have the opportunity to keep a DUI off their record and spare them a criminal record.
Oh, that's correct. In fact, there's another section that allows a reduction for, let's say, for example, their blood alcohol is at 0.5. Under a different code section, 23140, it's not a misdemeanor, it's an infraction, and it's not priorable.
So for someone who's underage, who gets a DUI and they're facing a criminal charge and also the possibility of the 1-year suspension, there's lots of things as a DUI defense lawyer that you can do to help to potentially avoid those consequences.
There absolutely is.